rather than before, but at least you've got a drink to sustain you. Thank you so much for joining us this afternoon. It's a real pleasure to have so many of you here at the Commission for this and a very important event for us, for LexisNexis and for the Australian Human Rights Commission. May I, Pitt Street, in this marvellous building for the Commission, acknowledge the traditional owners of the land, the Gadigal people of the Eora Nation, and to acknowledge in particular their elders, especially any who might be here today. So thank you for joining us. This is important. We're launching this marvellous publication, Federal Discrimination Law. It's the electronic version. I've just been talking to LexisNexis about why, but this is the modern way. It's electronic, and we've got to learn to use the electronic resources. It's an important partnership for us with LexisNexis, and I will in a moment be introducing Joanne Beckett, who's the Managing Director of LexisNexis. It's been a very exciting partnership, and one I'm particularly delighted by. May I also welcome Justice Melissa Perry, who's our keynote speaker today. It's a real pleasure to have you here. Thank you very much for giving us some of your time to an area of law that I know is very important to you, so thank you very much. I'm going to start, though, if I may, with some thank yous, and in particular to not only to the staff of LexisNexis, who've been so keen and enthusiastic on this project, but also, of course, the staff of the Australian Human Rights Commission. This has been a busy year. Every year is a busy year for us, I must say. But this year particularly, we've had a lot of difficult matters that the legal team have had to deal with. We can never plan for this, but they have been difficult. They've taken a great deal of the time of our legal staff, and despite all of that, they've nonetheless continued with the work in updating federal discrimination law. They've worked long hours, I know, over the weekends and the evenings, trying to fit it in to meet the deadline for publication with LexisNexis. And I really do want to thank them all, headed, of course, by Julie O'Brien, who heads the legal team. But we really do appreciate it at the Commission. And I think it's a very, very important piece of work to get this law out to an audience so that it's rather more accessible than it might otherwise be. The idea is to set out the federal discrimination law as it has been evolving. And as I was observing just a few moments ago, this was, the last edition was 2011. And in that time, there have been a lot of developments. And it's very important, as you all know in the law, to keep your knowledge of the law up to date. And we hope that this work provides an accessible description of where that law has changed. One area of law that's particularly included are the changes to the Sex Discrimination Act, with the inclusion of sexual orientation, gender identity, and intersex status as one of the bases of discrimination under the definition of marital or relationship status. Absolutely fascinating at the time, if I may say so, because when I first joined the Commission, we had the draft consolidation bill. It didn't go anywhere. But the one part of the bill that I thought was perhaps least likely to attract the attention and consent of Parliament was the provision on sexual orientation. But we all know that the consolidation bill itself failed, or was ultimately withdrawn, and the part that did get through was on sexual orientation. Didn't attract a great deal of publicity, but it's now become a better understood part of the Act, and some case law example practice work to illustrate how it works in practice. So that's one of the things to look out for. Briefly, to explain the rather important role, if I may say so, of the Australian Human Rights Commission, and that is that under discrimination law, you cannot go to the federal court with a complaint until you come to the Australian Human Rights Commission first. And that is why I'm so very proud of the complaints team that handle about 18,000 inquiries and complaints a year. It's a huge load, and a very small number of staff handle this work, investigating, and in about 1,500 cases a year that crystallize into formal complaints, we then try to achieve a conciliation of the matter. And we conciliate well over 70% of those matters. So I'm very proud of that work, because it does provide a genuine access to justice for a very large number of Australians. It's a service that's free. Entity who brings the complaint and the entity against which a complaint is made have the benefit of these services without charge. And it is remarkable that we have well over 90% satisfaction rate, even amongst those against whom a complaint has been brought. So it's been a successful practice, not something we can say a lot about in the public arena because it's confidential, and vital to that work is its confidentiality. But through that work comes our experience of how discrimination law works. And one of the things that I've learned since I've been president here now over 4 years is in the human rights and discrimination law area for most Australians. Because although I and my fellow commissioners are out in the media talking about asylum seekers, refugee issues, marriage equality, the detention of those with cognitive disabilities, race issues, special issues in relation to children, the issues that concern most Australians most of the time in terms of anti-discrimination law actually arise in the context of employment and the delivery of goods and services. About 2/3 of the matters that we receive are in those areas. So employment and fair access to goods and services are absolutely critical to the way and the way we can live our lives. So this aspect of the law, although, as I say, we don't say a lot about it in the public arena, is actually critical to thousands and thousands of Australians as we try to resolve the matters. About 2%, it varies, a year will go to the federal court, and there, of course, you get the benefit of a judicial determination. The text, I think, is going to be very useful. It also includes a very comprehensive table of damages awards that have been made, and they have been very important over the years in setting some clear benchmarks as to what those damages might be. So I welcome the publication of this new edition. I congratulate the staff for doing it, and in particular say what a pleasure it's been for us to work with LexisNexis. You're also the publisher of my book, and I hope you'll agree to do the next edition. There's always a hidden agenda. With those, just hopefully very, can I introduce Joanne Beckett? She's the Managing Director of LexisNexis and our partner. Thank you very much.
Thank you very much, Gillian. Justice Perry, ladies and gentlemen, good evening. It's an absolute privilege to be here this evening to assist with the launch of the Federal Discrimination Law publication. At LexisNexis, we believe that there's a fundamental relationship between advancing the rule of law and making real progress in sustainable development. As rule of law grows in any given country, so does access to employment that is free of discrimination, which in turn increases economic prosperity of that particular country. As families and individuals are empowered to live freely, infrastructure is stimulated, health and well-being increases, and acts of inequality and violence decrease. Sustainable development becomes reality. The correlation between rule of law and sustainable development is what initiated our global partnership with the United Nations Global Compact. The UNGC is the world's largest corporate sustainability initiative. This in mind, that we created the Business for Rule of Law framework to act as a guide for businesses to support and advance the rule of law. And it was while we were facilitating the Australian contribution to the Business for Rule of Law framework early last year that we were fortunate enough to secure the participation of the Commission. We found a common goal with the Commission: to protect the rights of Australians and reduce the number of people living outside the umbrella protection of the rule of law by working with strategic partners. We work on a number of initiatives, one of which is the reason I'm standing here today. Business, of course, can play a very powerful role in helping to drive change. By harnessing the innovation, creativity, and energy companies display every day in their commercial activities, we can open up new markets and opportunities through supporting the rule of law. By supporting the establishment of just and equitable access to non-corrupt legal systems and services, we can increase economic and social prosperity around the world. Through this process, we can play a fundamental role in enhancing the lives of billions of the world's most vulnerable people. At home, there's also a need to locally increase knowledge about legal frameworks and the ways in which people can access them to enact their rights. We do hope that this publication can play a very strong role in educating people about their rights and thereby help to protect the rights of all Australians. Discrimination Law is an online publication, as Gillian rightly said earlier, that examines the significant issues that have arisen in federal unlawful discrimination cases. Very comprehensive coverage of decisions in the jurisdictions, as well as highlighting a range of relevant issues of practice and procedure. It aims to bring an extra degree of clarity to often complex areas of law. Informed citizens that are able to understand and enforce their rights is essential in any society with a strong rule of law. In a position to further that development. By the same token, it is imperative that businesses and employers are aware of their obligations under federal discrimination laws, so they can uphold the principles of fairness and equality that are contained within. Publication, we are proud to be promoting fair and equitable access to justice, to the law. And we very much thank the Commission for their participation with us to help empower and protect the Australian public. I'd like to re-invite Gillian to the stand to introduce the keynote speaker formally. Thank you.
Thank you, Joanne, and I hope that this is the beginning of a beautiful relationship. We'll keep on doing this. And it's my pleasure now to introduce our keynote speaker, Justice Melissa Perry. Perry was appointed 3 years ago to the Federal Court of Australia. I used to know her many years ago as an international lawyer, and she did a lot of work in that area. She's been a great friend of the Commission in helping us with matters over time, and we really have valued you as a friend, understanding the work we do and providing us with some help on occasion. So thank you very much, and it's my pleasure then to ask you to give the keynote address. Thank you, Melissa.
Thank you very much for those very warm and kind words. I do feel a little like I'm coming home when I come to the Commission, and it was with particular delight that I accepted the invitation to speak tonight. In fact, I was just saying a moment ago to my associate, who is a budding international lawyer and very interested also in these areas, that having assured her that I would not accept another speaking engagement, this invitation came in, I accepted it, and then I told her. So fortunately she hasn't been too hard on me, told me off too much. By acknowledging also the past and present traditional custodians of this land on which we meet, the Gadigal people of the Eora Nation. Do so in the words, if I may, of the Aboriginal poet Jonathan Hill. Today we stand in footsteps millennia old, acknowledge the traditional owners whose cultures and customs have nurtured and continue to nurture this land. And women awoke from the great dream. We honour the presence of those ancestors who reside in the imagination of this land and whose irrepressible spirituality flows through all creation. I wish also to acknowledge and welcome warmly all of you who are attending to support this event and this publication. Those who have contributed to the updating and production of the 2016 edition of Federal Discrimination Law from the Human Rights Commission and also from LexisNexis and from AUSTLI, which is making the work available also online. It is, as I said, a very great honour to have been asked to speak. I'd like to begin with a few words about the history of discrimination law, stock for a moment of where we began. And I do so to illustrate two themes in particular: significance of federal discrimination law. The need for the enactment of those laws to be accompanied by education if they are to achieve the object of effecting social change by eliminating discrimination against individuals on arbitrary grounds. Federal discrimination law makes a substantial contribution to this process of education in terms of contributing generally to a better understanding of rights and responsibilities under the complex network of laws which comprise federal discrimination law. More specifically, in assisting complainants, respondents, and those who advise them, and indeed even associates who assist, to understand the processes prescribed by these laws and the substantive rights and obligations which they create. Promoting an acceptance and understanding of human rights as enacted in Australian law is indeed one of the express functions of the Human Rights Commission. In Lionel Murphy's biography, author Jenny Hocking refers to a letter sent from Professor Fred Hollows to Senator Murphy, who was then Commonwealth Attorney General. Later, Professor Hollows described his visit to the small town of Engonia, located 100 kilometres north of Bourke and close to the New South Wales border with Queensland. 9th of November 1973, and in my lifetime, and dare I say the lifetime of many here, Hollows and his team arrived in Engonia, where he was carrying out a trichotomy eradication program through the Bourke. The only accommodation in Engonia was the Oasis Hotel. Hollows was approached by the licensee and told that the Aboriginal members of his party would not be served at the hotel's bar and lounge area. If they required refreshments, he said, they must walk to the back of the hotel, where they would be served through a small hatchery whilst remaining outside. To remain in the hotel, Professor Hollows wrote to Senator Murphy, stating that discrimination makes my work, both as an ophthalmologist to the total community and as a person especially interested in improving Aboriginal health, very difficult. Some 12 days later, the Racial Discrimination Bill was introduced into the Australian Parliament, which would make unlawful conduct of the kind employed by the licensee at the Oasis Hotel. The enactment of Australia's anti-discrimination laws, a critical juncture in Australia's multicultural evolution. These laws were born of a period of great change in Australian history, as our domestic laws sought to enact the fundamental human rights and obligations that the international community accepted as the minimum standard. At the heart of those international developments, following the adoption in 1965 of the Universal Declaration of Human Rights, recognition of the inherent dignity and equal and inalienable rights of all members of the human family as the foundation, justice, and peace in the world. The first anti-discrimination legislation in Australia, if I may be allowed a slightly parochial moment because I'm originally South Australian, was the Prohibition of Discrimination Act passed in South Australia in 1966. The South Australian Parliament had been quick to act because the International Convention on the Elimination of All Forms of Racial Discrimination had been unanimously adopted by the United Nations General Assembly less than a year earlier in December 1965. In the following year, the Public Service Act 1902 was amended. Like Mary Gaudron, who was employed by the Crown Solicitor's Office in 1963 when she married, no longer had to resign on marriage from their positions within the Australian Public Service. The early 1970s then saw a dynamic period of law reform that included no-fault divorce, environmental protection legislation, and the taking of the final steps to dismantle the white Australian policy by removing race as a factor in Australia's immigration provisions. More so perhaps than at ever before in Australian history, the law was being used as a positive force for social change. Nevertheless, even at the time, such legislative reforms were seen by some as inadequate in addressing the roots of racism and other forms of discrimination in Australian society. A commentator writing in 1975, when the Racial Discrimination Act became law, observed that discrimination is not a mere growth upon the body politic, which can be neatly removed by skillful legislative surgery. It is a symptom of an ill that is within the body, a manifestation of a state of ill health which requires treatment as a whole. It cannot be denied that the Racial Discrimination Act has not eradicated racial discrimination in Australia. The other federal and state and territory, I should say, discrimination laws eradicated other forms of arbitrary discrimination. But to expect them to do so would be unrealistic. Nonetheless, as the Race Discrimination Commissioner wrote in Reflections on the 40th anniversary of the racial discrimination, no law can ever eradicate the social evil of racism. No law can ever banish hatred, ignorance, and arrogance. An instrument like the Racial Discrimination Act does make us stronger and more united. It can be said of our other anti-discrimination laws. The Racial Discrimination Act heralded a new era for anti-discrimination protections with largely bipartisan support. In 1977, the Attorney General Bob Ellicott introduced the Human Rights Commission Bill and announced the intention to introduce sex discrimination legislation. 4 years later, in 1981, Senator Susan Ryan, the first female senator for the ACT, and the third woman to hold a cabinet post in a federal government, introduced a sex discrimination bill as a private member's bill. It was designed to give effect to Australia's international obligations. There seems little doubt that Senator Ryan was motivated in part by her own experience. Her teaching career had been cut short when, after becoming engaged, she was told that she could not complete her studies, repay her scholarship funds. Her male peers, however, were free to marry and continue their studies on full scholarships. To erect these reforms was not always smooth. The Racial Discrimination Act barely survived a challenge to its constitutional validity in 1982 in the High Court. And there was a long and heated debate during 1983 over the Sex Discrimination Bill of social disaster and an 80,000-person petition opposing the bill. Until 1984, that Senator Ryan's vision of a federal law rendering discrimination on the grounds of sex unlawful was realised. Laws existed earlier at state and territory level. This suggests that laws such as these sought to shape rather than necessarily to reflect opinion at the time, capturing the aspirational values of a more equal and fair society. The limited capacity of law alone to effect social change was accepted and understood when these laws were enacted. And so typically, one of the express functions of anti-discrimination laws is education. This function is essential if the irrational and unconscious fears that drive racism and other forms of discrimination are to be addressed. With the elimination of such fears, an environment may be created in which mutual respect people of different cultural and ethnic backgrounds and different needs can develop to the benefit of each of us and of society as a whole. We all have much to learn from each other. Taking racism as an example, that process of learning is enhanced when cultural diversity that exists within society is reflected in the composition of the different communities within which we mix. And this includes our professional communities. Challenges in this regard are great. Australia is one of the 3 most culturally diverse societies in the world today. Aboriginal and Torres Strait Islander peoples currently number 700,000, or 3% of the total population of Australia. Approximately 28%, or 6.6 million people resident in Australia, are born overseas, while another 20% have a parent born overseas. In all, approximately 32% of the Australian population have a non-Anglo-Celtic background. Yet the Human Rights Commission recently reported that in corporate Australia, the ranks of senior leadership in the ASX 200 companies were overwhelmingly dominated by those of Anglo-Celtic and European background, and that all 40 university vice-chancellors hail from an Anglo-Celtic background, and I think now it might be 39, or a European background. The legal profession fares no better. For example, while Asian Australians comprise approximately 9.6% of Australia's population, a report prepared by the Asian Australian Lawyers Association in 2015 found that Asian Australians account for only 3.1% of partners in law firms nationally, 6% of barristers. Such statistics are disturbing and render our society the poorer. Research now bears out the many benefits to be gained from diversity in the workplace. It is said that a unique kind of learning takes place when people from different backgrounds come together, which does not occur within homogenous groups. For example, the Diversity Council of Australia published research in 2013 which showed that people with overseas immersion experience and multiple cultural identities display stronger than average creativity, problem solving, and product development abilities. To effect then real change, a proactive approach is required. We need to be proactive in our desire to learn from diversity and self-reflective about our own biases and prejudices. In this, training and education remain pivotal, as the recent Human Rights Commission report Leading for Change recommends. Also be aware that prejudices exist in the institutions and professions within which we work. For example, our workplaces all too often reward leadership styles that may overvalue self-promotion and assertiveness, while undervaluing or misinterpreting the deference and respect for seniority which is common in Asian leadership styles. Promoting inclusive leadership, that is, ensuring that certain cultural groups are not advanced over others, assumptions as to what leadership should look like, requires proactive steps to be taken, including mentoring and sponsoring, as the Commission has also recommended. Requires commitment from senior leaders within their chosen fields. Discrimination may not only have an intensely personal impact, but the victim may be unable to escape the environment in which the discrimination has occurred, be it a workplace, a schoolyard, or accommodation. Furthermore, the manner in which complaints are resolved has the potential to effect cultural change within an organisation. And so the resolution of complaints may itself have an educative function. For example, it may be that the complainant wishes to ensure that others in her or his position are not treated in the same discriminatory way, and may wish to avoid further complaints and to be seen as fair in its treatment of its employees. The nature of anti-discrimination laws therefore calls for a different approach to their application. For this reason, the preferred approach to dispute resolution is not adversarial, it's not in my court, but one of conciliation, with a view to reconciliation and healing. Raymond, for example, has explained in a paper published by the Commission, just with a more adversarial rights-based approaches to alternative dispute resolution focus on encouraging parties to understand each other's views, to maintain constructive dialogue, and to develop creative resolution options to address mutual needs and interests. The current structure of the conciliation procedures in the Human Rights Commission, which were enacted in 1999, aligns with this approach. Made at this time consolidated the complaints handling schemes under the sex, race and disability discrimination laws into a single uniform scheme, which age discrimination now also forms a part. The Human Rights Commission's conciliation process is designed to be informal, flexible, and one over which the Commission is an impartial third party. The Conciliation Conference is not, of course, a court, and the conciliations are, as Gillian has explained, held in private. The conciliator does not tell either side what to do. The conciliator doesn't act as an advocate. Rather, her or his role is to help both sides in a dispute talk about the issues, to assist them in understanding each other's perspectives, and to ensure that the process is a fair one for everyone involved. The conciliator can also provide the parties with information about the law and how it might apply to the complaint, and also about how other complaints have been resolved. As has also been explained, only where the conciliation is not successful can the complaint be terminated and the parties apply to the federal court for a determination of their rights. The benefits of this statutorily prescribed conciliatory approach before proceedings reach the doorstep of court are significant. Out the educative role which engaging such alternative dispute resolution processes may play, and an educative role in which the parties are actively involved, not merely one where someone is speaking to them. 2014 to 2015, the Commission conducted approximately 1,530 conciliation processes, of which 1,100 complaints, or 72%, were resolved. Information on the outcome achieved in conciliated complaints includes that 30% included terms with systemic benefits for people beyond the individual complainant. Examples include agreements to introduce anti-discrimination policies, provide anti-discrimination training in the workplace. The Commission's survey data also highlights the educative value of the Commission's complaint process, both for complainants and respondents, with 74% of participants in conciliated complaints indicating that involvement in the complaint process had assisted them to better understand their rights and responsibilities under federal human rights and anti-discrimination laws. So against this context, federal discrimination law is a valuable resource. It remains readily accessible online, Commission's and OSLE's websites. It provides practitioners and the public important information about the law and how it has been applied in the small percentage of cases that ultimately make their way to the courts. It assists the public in understanding their rights and responsibilities under the complex raft of discrimination laws at the federal level. It also assists individuals to understand procedural matters and to make decisions regarding potential terms of resolution. Particular significance, as has already been mentioned, are the tables summarising the damages awarded for economic and non-economic loss for breaches of each of the federal anti-discrimination laws, and the more detailed summaries of the particular breaches for which damages were awarded in each case. Being so clearly presented and accessible has the potential to assist greatly in setting appropriate levels of expectations and thereby facilitating the resolution of disputes through conciliation rather than adversarial means. I wish to close by extending my deepest thanks to the lawyers in the legal section of the Commission. Work and commitment to the preparation of federal discrimination law of their usual duties. I understand that this small team of highly talented lawyers put in an extraordinary amount of work involving many long hours and forgone weekends. I also wish to thank LexisNexis, who generously assisted pro bono in the production of this work. Volunteers from LexisNexis who also gave of their time to assist in researching, proofing, and editing the text. Again, many long hours, including on weekends, were given to the completion of this project by the volunteers from LexisNexis. This is an inspiring example of collaboration in furtherance of the better understanding and acceptance of human rights in Australia and the rule of law, are all the richer for your extraordinary contribution and dedication to this project. It therefore gives me very great pleasure to officially launch the 2016 Federal Discrimination Law and to warmly congratulate all of those involved in its publication and promotion.
Thank you, Melissa. That was a marvellous tour from Fred Hollows and Senator Murphy through today. And thank you so much for putting the effort into such a lovely, wonderful story, of course, that it's hard to imagine back in those days in 1973 when behaviour by the publican at that time. We have come a very, very long way. And I'm very happy that you mentioned the systemic change that can emerge from the work of the Commission, because it's not at all unusual to have a senior executive come into this floor to say they acknowledge that something happened that was discriminatory, and they would go back to their firms or companies and make sure that it wasn't going to happen again, and would look at systemic change. And I think that is one of the great outcomes of the work that's done. Of course, there's always more to be done, and I perhaps should close by mentioning the decision of the High Court yesterday that you might want to read. An interesting decision that raises some very, very important questions for in the future. A deaf person was denied the ability to become a juror for a couple of reasons. One, statutory interpretation, and the other, the difficulties that might arise in challenging a decision if there had been Auslan interpreters in the jury room, that it might taint the decision of the jury. Fascinating questions to which there are not categorical answers, but I think we can imagine that our new Disability Discrimination Commissioner, Alastair McEwen, will perhaps have a word or two to say about that in the future. But do read the judgment. It's extremely interesting and perhaps raises some other questions about how we can be flexible in understanding disability. So may I close then? I think that's covered everything. Thank you again, Justice Perry, to LexisNexis and all your really wonderful team there that have really taken up this project. And thank you all very much for coming. And I hope you enjoy federal discrimination law. Thank you very much.